In our last session of the day, I called this the future of the law. And really what I would like to do is have this session be interactive with really everyone, but to talk a little bit about why are there these challenges for residents and for communities, and also to kind of get a perspective of just how hard it is to resolve these if you are going to go with a lawsuit challenge. In that respect, I've invited Matt Pavone to be with us today. He's an attorney in Novato, California, just outside of San Francisco. Matt is actually the only person, I think, in the room, other than the dean, who I had met before I came to California. I've talked to many people on the telephone and by email for the last many months and even years in some cases. But a number of years ago, Matt invited me to consult on a case that he had. That case ultimately settled. But at the same time, what we can do is talk about what it was like for somebody to come into this industry as a raw outsider and find out what it was like. So Matt, please give us your presentation.
Good afternoon, everyone. Thank you, Catherine, for that introduction and for allowing me to participate in this panel discussion. You know, I look out over the room and you all look kind of tired and worn out from a full day of presentations by others, and I'm reminded of Elizabeth Taylor's 8th husband on the occasion of their wedding night, when he thought to himself that he knew what he was expected to do, but he wasn't sure what he could do to make it interesting. So with that in mind, I'll try to do the best I can to be brief, but also enlightening in the time that I have. I guess first, the basis for my presentation, why am I here? As Katherine said, I came into the issues that you deal with on a daily basis as an outsider. I was hired by somebody to represent him. He was a resident in a life care facility and brought me in because of concerns he had about the way his facility had been marketed to him, and also some billing issues that came up when he lived there. My experience was as a federal prosecutor. I dealt in lots of cases involving financial misconduct, and that was kind of my hook to get into the case. I didn't really know much about the industry. So when I was asked to appear here, I was trying to decide on what sorts of things, I might be able to bring to the table. But as I sat through and listened to Mr. Yee's comments and the comments of some others, I was very encouraged by the fact that the themes everyone was talking about at more of the global level are exactly the sorts of things we discovered very specifically in the case that I worked on. The case I had was a piece of litigation involving a very large-scale life care community operator who has facilities, several facilities in California, which actually was one of the issues in the case that I'll touch on in a few minutes, and then also I think in some other parts of the country as well. It involved a true life care facility, a life care contract where my client had purchased a very expensive living unit. And it was a nice unit, make no mistake about it, which was one of the issues in the case, was how do we present residents in that sort of a facility in a sympathetic way to a jury had the case gone to trial. Because it's a beautiful place, a beautiful lobby, statues, running fountains, the whole sort of thing. And yet some of the things we discovered there made it clear that the care that might otherwise have been reflected in the physical surroundings wasn't necessarily matched by the way the accounting was being done and some of the other practices that went on there. And then, of course, there were the monthly fees that you know about, which were raised typically on an annual basis, which was one of the very important parts of the case in terms of how those fees were being calculated. As I said, it was a very affluent resident population. I know enough to know there are lots of other senior care facilities where the population is not quite as affluent. Some of the things that our residents experience might be different because of the nature of the facility they lived in, but I think some of the general issues that are important to this conference about transparency, governance, and that sort of thing apply across the board, regardless of the financial means of the people who live there. I think the purpose of my presentation, as someone who's far from an expert generally in the field, is to offer some lessons learned. I listened to Mr. Yee's comments before, and he said, he was talking about the industry at the 30,000 foot level. And it seems to me I'm at the other end of that spectrum, more of a boots on the ground, up close and personal sort of a perspective. So let me make a few of those comments and try to touch upon the issues that I understand are so critical in the conference, which are marketing, governance, financing, which you heard about in the last presentation, certainly transparency and accountability. And these sorts of topics, I think, are woven throughout the opening remarks that I'm going to make. Marketing. The litigation in our case had two basic marketing issues. The general allegation was that the facility had been misrepresented in the marketing materials. And one of the other speakers talked about how when you enter into one of these very complicated life care contracts, you're not given the sort of disclosures that are comparable to a securities sale. You're basically given a little marketing pamphlet that has pretty pictures of the fountains and pretty pictures of the other amenities, but doesn't give you a lot of the real nuts and bolts of what exactly you're investing in. Our suit had two different things we thought had been misrepresented. The first one I'm not sure you've heard about today, which was this particular provider represents to having an affiliation with a religious organization. And certainly my client, when he entered into the contract, because both the name and the marketing materials touted this relationship with the religious organization, inferred certain things from that about who was governing the operation. He took great comfort in the fact that there was this religious connection, thinking that if there were problems, he could appeal to the church organization to get some sort of relief. And as it turned out, there really was no efficient or genuine relationship between the church and the provider. The church offered no form of relief. The church conceded it had no real control over the organization, and hence our allegations that there'd been a misrepresentation because it lured my client in particular into coming to the place, and it turned out that part of what he understood about the organization wasn't really true when he finally moved in there. And in fact, we tried to resolve the case early on by making pleas to the church organization to try to intervene and resolve the problems, and that's when it first became clear to us that they had no real control or management oversight of what was going on in the organization. So the suit alleged misrepresentations with respect to that. And then the other misrepresentations had to do with billing. And I'll talk more about billing as a specific topic, but on the misrepresentation side of it, with respect to marketing, the facility or the provider actually operated, I think, 5 different facilities in the greater geographic area where this particular operation was located. And in the marketing materials that my client and the other residents at his facility received, they only really featured the actual facility he was moving into. There was some brief mention of some other facilities, but there was no real clear connection made with the other operations that this place was responsible for running. And the reason why that was significant, which I'll talk about when I get to billing, was that it turned out that the costs and expenses of running the other 4 facilities were also factored in to the increases in the annual monthly maintenance fees at the specific facility where my client lived. And that became a huge concern to the residents because, as it turned out, they were the most affluent of the communities, and some of the others were struggling seriously, as you've heard from some of the other speakers here about the financial model. And it became apparent during the course of the litigation that the expenses at the other poor performing facilities were prompting monthly fee increases at my client's facility, and they ultimately were really shouldering the burden of the financial deficiencies at the other 4 facilities. So there were misrepresentations we felt on how the particular place was financed and operated. Okay, so that's marketing. Now, billing practices, let me drill down a little bit more. The suit alleged overcharges with respect to the calculation of the periodic monthly increases. And as some of you probably know, when you move into at least a life care facility, there's a huge outlay of cash to buy a place to live. And you get a life care interest where you get to stay there for the rest of your life, and when you die, it does not pass to your heirs, it passes to some new resident. And I think you've heard from some of the actuaries that one of the problems in these models is people are not dying fast enough, and people are living and requiring a lot of health care, and as a result, the units are not turning over the way the actuaries projected. And that is the way that these operations expect to generate a lot of revenue, is when people die, they sell the unit again to somebody else. Well, when those units are not turning over as fast as the actuaries thought they were, and the model is based upon, then the only other source of revenue is monthly fee increases. So the provider starts looking at ways to beef up the monthly fee increases to make up for the lost revenue from the lack of turnaround on the units. So there were 2 specific things that happened with respect to the billing practices. The first one was the way the monthly fee increases were calculated, and this is probably true in most of these facilities because it makes accounting sense, is revenue is determined, how much money did we make, what were our expenses last year, and to the extent the expenses exceed the revenue, you look at that gap, and the gap is essentially how much you have to raise revenue the following year to be able to make ends meet, right? Makes sense from an accounting standpoint. And obviously I'm simplifying it somewhat. You can also reduce costs, but that's difficult to do as salaries of staff go up and price of furniture and food and healthcare go up. Typically it's hard to maintain costs, particularly if you're going to try to provide the same level of service. So you need to fill that gap by raising the revenues. Well, what we discovered in the case was that the provider in their accounting practices, and I want to emphasize, the things we discovered were incredibly subtle. And one of the other experts on a prior panel talked about how, these contracts are so complicated, the providers have a hard time figuring them out, so they try to pass that risk on to the people who are buying the units. Well, the same is true in the accounting. I mean, the residents typically, while they're very bright people, often retired from very successful careers, they're at a point in their life where they don't want to be doing this sort of stuff every day. And it's very hard to wade into these financials and really figure out what's going on. Fortunately, we had a resident, not my client, but a different resident who was a retired chief financial officer of a big company. And he continued to be quite sharp. And in the free time that he had, he liked to go through financials, and he discovered lots of things that became very interesting to us in the investigation. The first one was that the provider was understating revenue. And the specific way they understated revenue that we discovered was the unit had a skilled nursing facility, which I guess is common in life care facilities because they want to be able to provide health care on site. And when the unit first opened, needless to say, the initial residents were healthy because they typically sell to people who at least are healthy when they move in. So they had a beautiful healthcare facility with a number of beds, and the beds, they didn't need the beds for the residents. So to make money and turn it into a revenue producer, they rented basically the beds out to other people who could come in, could be treated there. Well, those people paid because they didn't have a life care relationship. Well, that revenue should have been credited to the bottom line for the residents because it was revenue coming into the facility. And it wasn't getting credited to this formula. That revenue was left out. So therefore, the revenue looked lower than it should have been. So we had that problem on the revenue side. And then on the cost side, costs were inflated, in our opinion, according to the allegations in the complaint. And they were inflated in two different ways. Number one, they took into account depreciation of the capital facility, the deterioration of the building itself. And our problem with that was in all the marketing materials, the provider had represented that depreciation was going to be a factor in the initial purchase price. That when people paid for the unit initially, depreciation would be factored into the purchase price, but that once you bought your unit, depreciation would no longer be factored into the monthly fee increases. And our very sharp, elderly former chief financial officer determined that, in fact, depreciation was still being factored into the calculation of the monthly service fees. So that was a problem. The second thing that I've already touched on was we determined that the costs included the costs of operating the other facilities that the provider was running. And a couple of them for sure were in very serious financial condition based on our research and our investigation. And certainly the residents we talked to, and that were quite a few of them, said that when they moved in, they didn't understand that's what happened. And they certainly never felt it had been made clear to them that they basically were being asked to shoulder the expenses, not only of their own unit, but also of other units that were not performing very well at all. And in fact, said, had we known that, we wouldn't have moved in here because, first of all, we would have looked at the other units, and when we realized what a less strong position they were in, we would have had concerns about what it was going to cost us to be able to keep those places solvent, through the course of our life there. So we had those concerns and those allegations in the complaint. Clearly the case was settled at some point on confidential terms. There was no determination of responsibility by either side, no admission of liability, but those were at least the allegations in the complaint and what we were aggressively litigating during the course of the case. So let me just say a few things about lessons learned in these preliminary remarks. Let the buyer beware. If that's not already clear to you, and I know lots of people are talking about laws and statutes and ways to make things better for residents, But at least until we have every possible law we could hope for, and we have a way to translate these very complicated financial transactions into something that the typical senior can read and understand, let the buyer beware. Do not make the mistake of thinking that the place you're moving into has any particular interest in you other than as a customer, and that you are entering into the same kind of a business transaction like other things you might have done earlier in your life, like buy a car or buy your first home. They are interested in you to fill beds, to pay bills, so they can continue to operate and they can continue to, attract other customers down the road. In fact, the livelihood of the operation depends on it. It's a business for the provider. However well-meaning they may appear, and they may have good intentions. I don't want to disparage a lot of providers out there who I'm sure genuinely are interested in helping the elderly. But at the end of the day, they only help the elderly if they stay in business. And to the extent there are pressures on them, either because of poor management or because the model itself has some structural deficiencies, they then suffer this increasing pressure to try to keep the doors open. And if they're not getting turnover of units or they can resell at very high prices at whatever the new market rate is, they have to look for other ways to try to make ends meet. And if their only other option is to raise monthly fees on the backs of the people who live there, there's a pressure to look for ways, sometimes creative ways, sometimes very subtle ways that aren't going to be readily apparent to the residents, to be able to keep generating enough income to be able to stay in business. One interesting thing on my point that they view you as customers, in our case, the provider legally took the position that as a matter of law, it had no fiduciary duty to the residents. And we contested that strongly. We found lots of documentation where we felt in other materials they touted how well they took care of the residents. In terms of future legislation, I would recommend any state pass a law that makes it clear as a matter of law that providers of these sorts of facilities have a fiduciary duty. And let me tell you why that's important. In our case, there were issues about misrepresentations. Well, any seller of any service, car dealer or what have you, if they make affirmative misrepresentations, that's a fraud. And that's true no matter what the industry is. But omissions are not always the basis for a lawsuit. Because then you get into, well, what's the duty to disclose information? You can't lie, you can't misrepresent, but if you just don't say anything, that's a much tougher case. Well, if someone has a fiduciary duty, like a lawyer, a doctor, an accountant, or, we hope someday, continuing care providers, if they have a fiduciary duty as a matter of law, they also have an obligation not just to be truthful in what they say, but to, in fact, make all disclosures that are material to whatever the decision is that they're trying to encourage. So in our case, we had representations by the provider that we were hoping we could bring our action on. But we had lots of information we felt had never been disclosed one way or the other. For example, about the other 4 facilities being part of the math calculation. And we wanted to make the point to the jury that this provider had an obligation to make those disclosures, not just to be truthful in the things it actually talked about. And the provider took the firm position in court that we have no fiduciary duty. This is a business transaction. We were truthful enough in the disclosures we made, and you can't really hold us accountable for anything we didn't talk about at all. So that just underscores the point that when push comes to shove, if you're in litigation and you're some sort of a dispute, don't expect the provider to necessarily jump up and down about how they value you as a resident. It's going to be considered a business transaction. If you can afford it on the way in, I would recommend you hire an independent outside senior care consultant. And again, most people in this situation, I assume, don't have that kind of money. But if you do, even at a nominal price, it's not bad to get some sort of a third party with expertise, if you don't have that expertise yourself, to ask the right questions, to insist on examining financials, to do the kinds of due diligence that lay people, like most of us are in this area, are never going to think to ask. So I would certainly recommend that you do that to be able to verify marketing representations, review financials, that sort of thing. And then have your consultant explain to you what it all means, rather than relying on the provider, because remember, their incentive is to sell you the property. Where somebody you hire has an incentive to look at all the options, give you pros and cons, and help you make a decision. Stay alert and vocal. Fight complacency. And I have to tell you, what I experienced in this case was there's a natural inertia away from that. The people who go into these places are seniors. They've worked hard their whole careers. Now their children are gone, they've got grandkids, they have hobbies, they have things they want to do other than work hard reading financial reports. And I have to say, in some instances, I think the providers exploit that. And certainly in our case, our residents, many of whom were very capable people who were still very sharp, all complained to me that they felt basically like well-fed inmates. That was the joke they used to use. So we eat great food and we have nice places, but we're basically treated like inmates here, and we meet a very patronizing attitude everywhere we go. Consider the long-term economic viability of the type of facility you're considering. And I think you've heard a lot about that from earlier speakers. We found, and this now seems to be borne out by what some of the actuaries are saying, that the life care model in particular had problems. Again, the actuarial projections weren't panning out exactly as expected. Units were not turning over quickly enough. Healthcare costs were going up more than they expected. And those all created very, very specific problems for the life care model because the provider's basically stuck. They've signed these contracts, but the residents are also stuck. And I have to tell you, one of the things that became a problem in our case was that we had a concern about literally causing the model to implode. Because if we were successful in our lawsuit, the only money the provider had to be able to pay what we thought was fair in terms of reparations to the residents was their own money. So we had serious concerns about the viability of the litigation because we thought, well, we may win the battle but lose the war because we're basically going to push the provider into greater financial distress because the only way they're going to be able to make good on all the money we thought they had wrongfully diverted from the residents was to take other money of their limited funds to try to give it back to the same residents. So you have that concern. Make sure that if you're going to move into a facility, you have some meaningful input into the way the place is operated. You're not treated like inmates or potted plants. You have voting representation on key management committees. Truly meaningful access to financials in a way where you understand what's going on. So there is that kind of accountability. And I would say make sure you have a viable remedy and exit strategy if something goes wrong. And again, the big problem in the life care model is our residents really had no way out. They signed a life care contract. There was a very limited refund period. And then the refund dropped dramatically. And so once the residents are there for 6 months, 9 months, whatever the case may be, they really had no way to get their money back. So the provider often said, and they said to our client from day one, you want to move out, move out. We'll help you pack your bags. But he was at a point in his life where he was in his late 80s, and that really wasn't a viable option. Physically, he couldn't do it. Financially, he probably could have done it, although it would have been a major financial burden for him. But for many of the other residents, they'd expended the vast majority of their life savings to move into the place. And since they weren't going to get any of that money back, they were trapped. I mean, they had no place to go other than out on the street. So make sure wherever you're going, you've got some viable exit strategy. So if the thing doesn't work out, you've got a way that you can get out of there. Because I do think management in that circumstance can use that to their advantage because they recognize the residents really don't have much choice. And as a result, it affects the way management treats the residents. I think that's why we ran into a very patronizing attitude. We'll take care of you. We know what's best for you. Because they knew at the end of the day, the residents really didn't have a lot of other options. And then even litigation was a problem, not only because the funds to make remedy belonged to the residents in the first place, but the costs of litigation were passed back on to the residents. After we filed a lawsuit in the next year's budget, there was a line item in the budget for litigation costs. So they were also going to the residents saying, now you have to pay for the lawyers who are suing us to do what they're alleging we should have been doing in the first place. So there really are many, many ways that the residents suffer in those sorts of situations. So in conclusion, I would just say, the same practices that should be followed in any other major decisions of your life, buying a car, buying a house, deciding where your kids or your grandkids are going to go to college and how you're going to pay for it, all apply at least as much to this decision because of the amount of money involved and the significance that it plays in your life. So either do your own homework, or if you're paying that kind of money, pay a little bit extra money to get some outside independent person whose opinion you can truly have confidence in to brief you and do the homework and help you shop for places so that you get a good result. Because at the end of the day, this is a kind of decision where you may not have a lot of recourse if it goes wrong. And as a practical matter, if it doesn't work out, there may not may not be much you can do about it because you have limited funds at that point. You certainly have limited energy at that point, and you may well have limited time to do anything about it. So it's important to get the decision right. And with that, I'll conclude my opening remarks. Thank you.
Well, thank you very much. Well, if you feel like Elizabeth Taylor's last husband, I'm not sure who I feel like, because we are definitely at the end of the day. Let me say, first of all, that I've really appreciated the candor and on all levels from all different aspects of this vibrant connection in speaking today. I think we have identified, many of the issues, and I think at the same time we've also touched on some of the remedies. I was particularly impressed, for example, when Bob Thompson said today that he knows there are at least 3 areas that he would like to see addressed in the review of regulation in California. He pointed to the question of financial stability long-term, that's going to be a major focus, that monthly care fees and how to handle the increases on monthly care fees should be a focus of future legislative review. And then finally, this question of resident involvement and the importance of resident involvement could also be a part of this reconsideration of California's laws governing CCRCs. I first began looking at CCRCs, as I mentioned this morning, in 2006. And I did so because of resident groups coming to our Elder Law and Consumer Protection Clinic at Penn State University. And I suggested to them that they hire private counsel. And they quickly explained to me that really all of their funds were tied up in the community that they were in, and they no longer had that kind of disposable income. Pennsylvania tends to have a very strong, vibrant CCRC industry, but it also attracts somewhat lower income residents, people who are putting all their money into their entrance fee and monthly fees and don't have that extra disposable income that perhaps somebody in a higher market might be. And they also felt like they were trapped. And so that's one of the reasons why I agreed to take a look at this, and why over the years I've continued to take a look at this. I've now met with resident groups at their invitation. I've never once marketed myself at all. In fact, I probably try to do the opposite. And I've now spoken to resident groups in Florida, Maryland, Virginia, New Jersey, Massachusetts, Connecticut, Arizona, New Mexico, Oregon, and California. And I'm probably forgetting something. That's not counting the people I talk to on the phone. Those are the places that I've gone to speak to resident groups or somehow meet with resident organizations. And during that time, there are many consistent things I've heard. Maybe the most important is how much the residents value their communities. They really do like their communities, and they want to see this community succeed. They like the model. And so they're not driven by feelings of distaste. They're driven by this desire to keep it going. The other things that I have heard, and I'm just going to give you my little list, and many of these are already addressed by California's legislation. First, there's 7 of these. The right to organize and advocate for themselves and their fellow residents. Well, California has addressed that issue in their regulations. The right to be free from retaliation when pursuing their desires or their rights. California also has addressed this right in their legislation. The right to receive regular, accurate, and detailed financial information that affects current and future operations at the CCRC. I think that California does address that, but the next item that I've heard from residents consistently, I think, is the greater issue. The right to receive financial information in a form that is understandable to the majority of current and future residents. So I think that is one of the things that the industry needs to address more than legislation. You can legislate till the cows come home, But if the industry doesn't embrace the concept of transparency, and I think this was Mr. Yee was saying as well, it's not just the CCRC industry, it's the accounting industry, it's the actuarial industry, all of them combined are providing the strength of information, the clarity of information, the trustworthiness of information that's going to be important to the future of the industry. The fifth item that I've heard regularly, the right to an effective voice in financial decisions that may impact present and future stability of their community. And sixth, the means to enforce their rights by reasonable process. One of the questions on number 6, rights to enforce their rights by reasonable process. Do we really have to have lawsuits to do this? I'm sure that Shannon Armstrong and Mr. Pavone would say yes, in one sense, because it keeps them employed. But probably there should be some considerations. Are there other ways to do this? And one of the things I've often thought is, does there need to be an independent evaluation organization that can come in and act in a sense as the mediators did in the Rogue Valley Manor case, but do so with that credibility of voice because they know both sides of the industry? Is there a place for an evaluator that has credibility with both sides to come in and speak? Number 7 is probably the toughest one and what we spent most of the time on today, and that's what I call the residents' desire for affordable stability. Not just that they have a place to stay that's very nice, but someplace that they feel is an investment that they can justify making for the rest of their lives. And I think that affordable stability concept also dovetails with what the industry wants to provide, certainly on the not-for-profit side. I think that's true. But I also think that, you know, for the most part, on the for-profit side as well. In the last few months, I've also spoken to state legislators at the request of legislators who have invited me as an expert witness to speak about resident rights issues and resident responsibility issues. One of the pieces of legislation I was asked to speak about in New Mexico last month was the question of voting membership on resident governance, or on provider governance boards of directors usually. New Mexico was considering adopting a state law that required voting membership on their boards. Actually, I say New Mexico, that was Virginia. Virginia was considering that. New Mexico, the issue was who was going to regulate CCRCs. In New Mexico, the regulation was in a social services type of agency. It was a Department of Aging. And the recommendation, as is being discussed in California, was to move the regulation to the Department of Insurance. Ironically, I was coming from Pennsylvania, where the regulator is the Department of Insurance. And many of the residents in Pennsylvania, that's the people that started off hiring my clinic to begin with, really felt that that was not adequate regulation. I think more important than who does the regulation is their commitment to understand the industry. So the label on the door as you walk in the door is not the most important. It's the commitment to understanding the industry. And it appears to me that certainly this level of sophistication with actuarial standards is becoming more important. So if it's the Department of Insurance is the most important regulatory agency because they already are used to working with actuaries, well then that's fine. But any department can work with actuaries and do so in a logical and appropriate way. So I would encourage anybody to be more concerned with the commitment to the regulation, which frankly I think exists in California, than with whether it's in a particular department. On this question about voting membership on governing boards, I've come to believe as a result of my work with a number of states that this is important. In New Jersey, one of the states that took this on rather early, New Jersey adopted a mandatory requirement that each board have at least one resident as a voting member. It's worked. It certainly has not been a negative. And what many of the residents have reported to me is that it starts a platform for trust to be built, because the other members of the governing board may be getting all of their information from one person, the CEO of the operation. Now they're getting additional information, and sometimes it matches and sometimes it doesn't, but the rest of the board feels more informed. In addition, the education process for the voting members is important. They are going to learn about their fiduciary duties to the entity. The fiduciary duty concept is at the core of the challenge for the future of CCRCs, I think. When I first was asked to look at the issue of CCRCs, one of the residents said to me, well, doesn't the organization, doesn't the provider have a fiduciary duty to me as the resident? And I, coming from a background that didn't have anything to do with this industry, said, well, frankly, no. The ordinary way in which fiduciary duty works within a corporate structure, an entity structure, is that the governing board has the fiduciary duty to the entity, to the survival of the entity, and not to the residents. Can you also have a fiduciary duty or take into account the interests of residents directly? The answer is yes. And many states have recognized that by amending their fiduciary duty laws in the corporate context, by allowing the boards in doing their fiduciary duty to also consider the needs and interests of other members, including the service population served by that corporation. So there's a model for this, blended fiduciary duty that I think is out there and possible. So when the Oregon suit was first contemplated, I was asked to write an editorial piece, and I said, this is going to be one of the questions, is what is this fiduciary duty from the parent organization to the residents directly? And I think that in addition to the challenges that exist for CCRCs because of the financial world, I think that as the more informed consumer ages, and as the more informed consumer with access to the internet ages, and thereby has this greater ability to communicate, the industry that's successful, the CCRCs that are successful, are going to be the ones who embrace this concept of a blended fiduciary duty. It already exists. In fact, it already exists in California. California has at least one CCRC parent organization, networking organization, that now has residents on their, voting members of residents on their boards. I invited the CEO of that organization, and unfortunately that individual was unable to come here. But I said, well, how's it working? And the gentleman said, better every day. So again, they're recognizing that this embrace of having residents be a functional part of the structure, of the governing structure, is one of the ways to improve the trust levels, the communication levels, and the financial accountability between residents and the provider structure. At the same time, I also have to often say tough news when I talk to residents, as much as Matt has probably suggested is important to talk to people about before they go into a facility. And I have to say, look, ultimately, the fiduciary duty has to be to the survival of the organization. So if it's a question between the short-term needs of residents and the long-term survival of the CCRC, the fiduciary duty is to the long-term survival of the CCRC. But hopefully by having voting members on that board, now the voting members are going to be part of that education process, and the rest of the residents are going to see that the long-term interests of the entity is going to be served because they have that voice there as well. One of the biggest challenges is it was mentioned earlier today, what about putting that new roof on? What about doing that expansion? I don't want to live in construction for the rest of my life. it may be that it's best for the CCRC's future to do the modernization, to do the upkeep, to do the expansion, to make it attractive in the future. And those hard judgment calls are part of the governing structure. And I think involving residents in that hard decision process makes it a more trustworthy process. At least that's my impression as a result of looking at this industry for the last 6 to 7 years closely. So with that, that's going to be the end of my opening remarks. I think at this point, really what we've done is we've teed up the question of fiduciary duty as kind of a theme for today. Would you like to offer additional comments, Shannon, or would you like to open it up to questions?
Sure, just a few additional comments on the fiduciary duty. As I described earlier, one of the key issues in our settlement was that we were able to have PRS agree that it had a fiduciary duty to the basic subsidiary organization. Now, notably, that wasn't that PRS had a fiduciary duty to the residents. That would have been, I think, a much tougher sell, although it was a tough enough sell getting the admission on the fiduciary duty to Rogue Valley Manor itself. I think one thing that's interesting, though, is that in the context of the charitable trust doctrine, which is another doctrine that I think can be used to establish a fiduciary duty on behalf of residences of the communities, and that doctrine basically says that the beneficiaries of a trust have a fiduciary duty as well, or are given a fiduciary duty as well, and that law has been used to also apply generally in the nonprofit context. So I think that that's another possibility, is having that law applied more generally to the nonprofit context outside of the charitable trust context. I think that's one possibility for getting the fiduciary duty through litigation. But as Professor Pearson, explained, litigation isn't always the first option for anybody. But I think there are times when it's necessary.
Well, let's open it up to questions.
I wanted to make one more comment about the fiduciary duty issue. The traditional corporate fiduciary duty speaks of the fiduciary duty of a board of directors. It's the fiduciary duty of the board of directors not to the entity. The fiduciary duty of the board of directors traditionally is to the owner. It goes up to the shareholders. And consequently, I understood the victory in RDM was that the directors were recognizing their fiduciary duty to the subsidiary, to the entity of which they were directors, as distinguished from their fiduciary duty to their parent. And since the only purpose of that entity is the care of the residents, that's the only reason it has for existence, well then, by implication, it must be the case that the only fiduciary duty to the entity, you therefore have a fiduciary duty to the residents, because there is no other purpose to this entity. And that's a big victory.
Right. No, I completely agree that it is a big victory, and I think that a lot of the sort of there's nonprofit model regulation. I forget what it's called, but it is looking at this idea of the member, the sole corporate member of a nonprofit having a fiduciary duty that hasn't been recognized before. So I think the law is moving in that direction, but the law moves slowly generally.
One of the things that I made the argument in nonprofit organizations, nonprofit CCRC structures that have these supporting members and supported organization structures under a particular section of the tax code, that tax code provision was actually intended to make the supporting organization more accountable to the supported organization. And somehow that was being used as a argument that the supporting organization must control the supported organization in terms of its corporate structure. And I think that's exactly the wrong reading of that tax structure. I mean, I think the tax structure had a tax reason, a nonprofit tax reason, but I don't think that that meant that the control had to be there. And that was a convenient explanation for it. Certainly I can see why the parent organization would want to have control of the supported organization. But, I don't think that had to be as a result of the tax structure. I think that was kind of a twisting of the tax structure concept. But why don't we go to others and then we'll come back to you. Any other questions or comments? Let's go over here.
In the rest of the corporate world, regardless whether it's for-profit or not-for-profit, there's somebody out there looking at these places, and you mentioned independent evaluation. There's always stock analysts or bond rating companies or whoever, even the charitable organizations get evaluated by somebody. Isn't there no one looking at this industry and publishing some kind of rating system, or any comments at all?
Well, for instance, I know for Rogue Valley Manor and for Pacific Retirement Services, the bond rating agencies do give a lot of information. That's been something that's been a challenge with our case, has been that there's been a bond financing that's been going on at the same time, simultaneous with our litigation. And it's a really big deal, not just for PRS, but also for Rogue Valley Manor, therefore also for my clients. So we've been dealing with the bond agencies, the rating agencies, as this has all been going on. A lot of it, I think, is, we always need to think about who's giving the information, how, what their incentives are for what information is given. I don't think any of those sort of, in my experience, all of those sort of financial reporting structures have holes. So I think it's important for us to sort of look at it with a critical eye. I don't think there's a perfect solution that's out there right now.
In addition to that, too, the bond companies themselves have been, been pointed to by CCRCs so that their bond rating is a part of their marketing strategy. Before the 2008 financial crisis, that was one story. Since the financial crisis, I think the bond companies are doing a much better job of evaluating CCRCs. I think that before the 2008 financial crisis, everybody was enamored of this idea that everyone's home was going to sell for 50-60% higher than what you purchased it for, maybe 300 times what you purchased it for, and the entire industry was depending on that when they were doing these evaluations of the future of the CCRC industry. I think the bond rating companies have become much more realistic since 2008.
Can I make a comment about the alternative dispute resolution when there are conflicts between residents and the provider? As a matter of contract law, lots of other relationships where there's a contract signed have a provision in them that requires the parties to pursue some sort of alternative dispute resolution, typically mediation, before anybody can file a lawsuit. And I think that's one way to keep from having the residents be in a position where they've got to file a lawsuit to get any sort of genuine relief. You may recall in my case, we tried to go to the church thinking they might serve in that capacity, and we were quickly told that wasn't going to happen. However, if there is going to be a mediation provision in these contracts that the residents have to sign, it's got to be legitimate independent mediation. Mm-hmm. It can't be somebody who, again, is just a shill for the provider. So there needs to be a selection process where the residents are also satisfied that the person who's mediating it is truly an outside independent. The other thing that occurs to me is how they're going to get paid for. Because typically all of these kinds of things get paid for out of the budget the provider has, which comes from resident fees. And if it's not being done reasonably and efficiently, and the residents see it as just another way the residents are getting gouged to provide some sort of extra service for the benefit of the provider, the residents are going to be very disenchanted with it, and it's probably not going to be very successful. But at least as a concept, that's something that could be considered.
And that was actually something that was really important in our negotiation in the Rogue Valley Manor case, was simply an alternative dispute resolution clause for any disputes arising from the settlement agreement. Our settlement agreement isn't a simple sort of, you pay me this much money and I won't sue you. It requires a PRS and Rogue Valley Manor to take several actions over a period of months that is actually pretty complicated. So we wanted to make sure that there was a way to enforce that was going to happen after our client signed the settlement agreement. And so that's why we have an alternative dispute resolution clause that allows us to do a rather quick arbitration if necessary to get what we need. And that would be through Rogue Valley Manor actually being able to assert those rights, since Rogue Valley Manor is now, just to sort of update you on where we are, as of yesterday, PRS just voted to add the new folks onto the Rogue Valley Manor board, and that will take effect April 15th. So as of April 15th, we'll have a new board that will have 2 resident directors, 1 director that has been on now for a while, that's sort of a neutral director, and then 6 new community directors that were chosen by a joint nominating committee comprised of residents and of PRS board members. So we're hoping that that Rogue Valley Manor board will be able to basically police the settlement agreement, but as well, the steering committee has created a compliance committee of, I think, six residents of the steering committee, a lawyer, I think some others with finance backgrounds, that are really sort of making sure that all of the T's are crossed and the I's are dotted on the settlement agreement over the next 6 months to a year, probably.
It's interesting as well in looking at these types of disputes, how frequently the weapon that is used against the residents' concerns is the fact that you're going to pay for this dispute. And so in successful disputes, it has almost always been because, well, successful from the resident's perspective, like may not be success from the provider's perspective. It's almost always been because either there was a fundraising that was successful on the part of the resident's side, as occurred in Rogue Valley Manor, or there was somebody who had enough money personally that they were willing to fund their own litigation. In several of the litigations that had to go that far, there has been an ability to settle the case with the provider paying for the fees, which means that there may be a flow downstream of that cost shifting. And in some cases, there's been a piercing of the corporate veil on the for-profit side, allowing the shifting or the finding of fees and the finding of additional money to come from somebody higher up the food chain within the corporate structure. That was part of the reason for regulation in California to begin with, at least the current wave of regulation back in the 70s. We mentioned it earlier, the Pacific Homes case, where it was a church-affiliated group of CCRCs in the late 70s that just didn't do very well financially. And in fact, they did so badly, they filed bankruptcy as a corporation. And the church affiliation took the position they had no obligation to Pacific Homes Corporation, that it was entirely dependent upon the bankruptcy or lack of success of the workout in the bankruptcy, that the church itself had no responsibility. And that case ended up ruling, the court ended up ruling that no, the church affiliation could have financial responsibility in that particular case. And eventually the case was settled after, I think, about 30 days of trial. The history of that case is captured in a book. It's a very interesting history because it was an attorney who went on to have problems of his own. That was his first big success in life. And he went on to win many more cases before he began to leave his own press and ended up being the target of suits. But as a result of that early case, the Pacific Homes case, many CCRCs are wiser now themselves. They have done a better job of creating corporate structures that limit their liability. And certainly it's also meant that not-for-profit providers are more careful about how they're structured, so that the church affiliations, the benevolent organizations associated with them are more clearly separated in terms of their financial responsibility. And again, that requires very sophisticated consumers to understand that what they're looking at is two separate entities usually, the CCRC entity and whatever the other entity is that's the sponsoring organization or the affiliated organization may have very little financial responsibility, if any, to the provider itself.
I have a rather complicated question. And if you don't want to answer it, just tell me and send me an email. Because, look, I tend to look at the problem that Rogue Valley Manor had as an economic entity that put itself in a position of no competition. It was, in essence, a perfect monopoly. It owned both ends of the business deal and was dealing with itself that way, so that it cut itself completely out of the market. one of the things that, and that's one of the problems you have, is that there's no market mechanism. Now, go to the settlement. The settlement says we have independence, a measure independence in Rhode Valley Manor. But then we also have a fiduciary duty. But they still got no market mechanism, according to your analysis, if I heard you correctly. What you were saying to me is because of 4 other factors, when the time comes to renew the management agreement, they don't have a choice. Rhode Valley Manor still has to go with the Pacific retirement system.
Well, I think that it's definitely true that Pacific Retirement Services, PRS's tax status depends on it being a supporting organization to Rogue Valley Manor. Whether Rogue Valley Manor's tax status depends on PRS being its supporting organization, I think is perhaps an open question.
Yeah.
Now, and I think that you're right, that we do have an issue of there being no market, and what does that really mean when there's a fiduciary obligation? So really, can there be a renegotiation? I think that there can be, and the way, at the end of the day, they may know that they have to live with each other, right? But that,
hopefully.
right, let's say that is the conclusion we come to is that they have to live together and they need to find a way to make it work. And that that PRS has a fiduciary obligation to Rogue Valley Manor. So in my mind, the way sort of I see that negotiation working is that Rogue Valley Manor has obviously reduced leverage because if they can't get rid of them, right? They know they have to live with them. At the same time, PRS has a duty of good faith and fair dealing in negotiating that contract and has a fiduciary duty in negotiating that contract. And as I don't believe has been the case in any of the other management services agreements, I'm sure when the new management services agreement is renegotiated, Rogue Valley Manor is going to be represented by separate counsel than Pacific Retirement Services, which I don't believe was the case before.
The settlement enables separate counsel for.
And get separate pricing.
Exactly. So I think this will give.
And I thought that's why you did
Shannon,
that.
can you also just
Summarize the
reiterate
question.
what he's saying?
Sure, I'm sorry. The question was to how are we going to deal with the situation of there being no market in the relationship between Rogue Valley Manor and PRS if the organizations are tied to each other? What is that renegotiation when the current management services agreement needs to be renegotiated? What is that going to look like?
Yeah, and what's the impact of the fiduciary duty?
I think that it's going to, well, I think that you can have a contractual relationship and a fiduciary relationship. Those duties are not mutually exclusive. But I think that they're going to have to give full disclosure. They're going to have to give a duty of care. And I think one thing that we haven't had a lot of time to talk about is sort of the new emerging duty in not-for-profit organizations is the duty of mission and the duty that folks that are running not-for-profits have to follow the mission of the organization as well.
It may be too long to go further on that, unless it's a clearer question.
Oh, sure.
I think there was a question over here.
I wanted to ask Matt a question, and also for Shannon. In the course of your work on these cases, did the issue of contract being an adhesion contract that would by a court be construed against the draftsperson in the event that we're did that argument ever get made?
Absolutely, from day one. And would have been had we gotten that far.
Can you repeat the question?
No. The question was whether the topic of an adhesion contract was an issue in either one of our pieces of litigation. And for those in the audience who may not know what an adhesion contract is, under the law, if one party has a disproportionately strong position in the negotiations, such that they draft the contract and offer it to the other side on a take it or leave it basis. The classic example is when you pull into a parking lot and the machine kicks out a ticket and says they're not responsible for anything. You haven't really negotiated those terms. In those situations, any ambiguity in the contract is always interpreted against the drafter. So if they're not crystal clear in what they're doing and it's left at all ambiguous, the law resolves it against the drafter on the theory that they're the ones who wrote it. The other side had no opportunity to clear up the ambiguity. Therefore, the other parties unfair interpretation gets credited. So clearly in our litigation, the argument would have been that because there were representations in the contract that were ambiguous, all of those ambiguities should have been resolved in favor of our client because he had really no say in negotiating the contract. He either had to sign it as is or they would not have extended it to him. Shannon?
That's all completely accurate. That's the same strategy that we were planning to use in our case, and we had not just the residents and care agreements that we believe would be all interpreted, any ambiguities interpreted in favor of the resident, but also the management services agreement with Rogue Valley Manor was another key part of our litigation, and that also we believe would be negotiated in favor of Rogue Valley Manor since it was not the drafter.
We have two, one a question and one a comment that's coming in from our streaming audience, our internet audience. First, the question. For transparency, why can't providers put all of their reports on the internet at the time they file them with the regulators and the bondholders? I suppose the short answer to that is there's nothing that precludes it. There may be a competitive advantage among the industry for not doing it, so that's why they won't do it. And probably because they're not required to do it, they won't do it. There's also probably a factor of them being large, and that may be why they don't do it as well. I can say that in Pennsylvania, one of the amusing stories about that very fact was the annual reports that are filed in Pennsylvania by CCRCs are public records. And so I decided to go down and take a look at them. It was certainly much easier than going to all 200 CCRCs in Pennsylvania. Pennsylvania has a lot of CCRCs. And so I made an appointment and went down there, and they said, well, where would you like them? And they gave me a little back room, and they rolled them in on a trolley, all of these annual reports. And I said, well, when were these filed? And they said, oh, we're almost at the end of a reporting year, so we'll get a new batch next month. Well, so it was very interesting. 180 annual reports, and the seals on them had never been broken. And so that told me that the Department of Insurance, in that case, was not doing a whole lot of reviewing of the documents, but they were doing a great job of collecting the documents. And so that's why commitment to, to taking the review process seriously, either as a matter of statutory obligation or because you're interested in it, is important. The comment that's also been offered here is from somebody on the internet streaming, or who's watching the streaming video, who said it's difficult for this individual to fathom that the contract that the person foolishly signed is enforceable, and they feel that they're enslaved. And I think that's unfortunate when that kind of an observation is made. There's definitely a disconnect between marketing and closure on these contracts that is at odds. The very first article I wrote about CCRCs, before I was just looking at the industry at the beginning, I said, frankly, lawyers have not done a very good job of representing residents. Not because they don't understand the contracts, but because they don't price their legal services for residents, prospective residents, in a way that encourages residents to bring the contracts to them to discuss them with them. Lawyers want to charge big, huge fees. And, and residents don't want to pay a whole lot of money to have a contract reviewed. And so there's not a lot of lawyers out there who understand CCRC contracts. The two individuals sitting next to me probably understand them better than 98% of the rest of the attorney world, including elder law attorneys, understand them. Of course, on the other hand, I also point out that there's a surprising disproportionate number of attorneys in CCRCs. Now, maybe that's because the CCRCs know better than to let them in. Your comments about either of those?
Go ahead, Shannon.
No, you go ahead.
I have some comments, which is my experience, and this is very important, is that because a lot of the residents are really smart, retired people, not just lawyers. We had a few lawyers in my case who provided a lot of advice to us novices in the area. As I already mentioned, we had a CFO who in his free time, his hobby was reading these financial statements. And he had spent years researching this and basically handed us a lot of our case on a silver platter. So the caution to the providers is treat your residents with disrespect at your own risk. Because if they're unhappy and they start getting a sense that they're not being treated fairly, they have tremendous expertise and they have a lot of free time. And it's gonna end up working against the provider, because we had very motivated residents who were very cooperative in terms of providing us information and insight. And in many instances, they truly were experts in the way CCRCs are supposed to operate. So if those people are not being taken care of, you can't be patronizing toward them, because they're still plenty sharp enough to be able to make a lot of trouble for the providers if they don't think they're being treated fairly.
One thing to add on the reports being available, one thing that we're able to do in Oregon is we can get those reports online. So we were able to get many of the reports for Rogue Valley Manor and PRS through their website and do that really quickly, which was really great. And we do have a pretty active regulatory agency there, and I think that they had read the reports, so that was good. But that it goes to the point that was just made, and that is that there had been complaints made about Rogue Valley Manor and about PRS to the state agency, and so they had started an investigation, and they had been looking at some things. I wouldn't say they formally started an investigation, but they knew what was going on. So they were very up to date on everything that was happening as it happened, and that was sort of, I think, maybe one of the benefits of being in a state that's a little bit smaller and has fewer CCRCs, is that it's a little bit easier to get the attention of the regulators when you need it.
Let me make one additional comment too about making these reports available. You know, we all have to face the inevitable problem of just resources, and particularly now in the state of California with the serious budget deficiencies. I think one of the problems we ran into is in this industry, even if the state has good intentions, they just don't have the bodies to go through these boxes and boxes of annual reports. So typically the only providers who really get looked at closely are newer providers, providers who really commit such egregious misconduct that, you know, it's on the front page of the newspapers and the state really can't avoid it. If you're dealing with some of the other more well-established providers who by and large seem to be providing, you know, decent housing for people, the kind of subtle things that I described in our litigation and that maybe Shannon ran across in her case just are not obvious enough to the regulators typically to be able to invest that kind of time in it, because they just don't have the resources. So they go after the low-hanging fruit, the cases where it's real obvious, it's glaring, it's egregious misconduct, physical abuse, you know, stealing from people in a much more egregious way. And, you know, in a lot of the sorts of things I'm sure you've heard about today, it's not that obvious, but in the grand scheme of things, it's nevertheless carrying a big impact for the thousands of residents who are affected by those policies.
Any final last questions or comments from the audience? Well, let me say this. I think that we spent a lot of time talking today about all the different issues, and hopefully this is the start of a dialogue. It's not the end of the dialogue. Because I certainly have heard important ideas emerging today, even just as simple as Oregon having a mechanism by which you can access financial documents online. Sounds like that's a model out there as well. And the other part I want to say is I know from experience working in this industry that we've been talking about the problems in a relatively small component of the industry, and there's a larger component of the industry out there that's doing quite well financially and is making residents very happy both on a physical level and on a financial level. And so we're not attempting to say that this industry itself is in trouble. There may be aspects of it that need to be changed, there may be aspects that can be done better, and certainly there's financial transparency issues that need to be addressed. It sounds like from pretty much everyone's perspective. And then finally, let me make a comment. In 2010, the United States Senate had the Special Committee on Aging take a look at CCRCs. It was a periodic review. It was a response to the 2008 financial crisis, and particularly the bankruptcy of one of the larger players in the CCRC industry on the East Coast, Erickson Communities. And the General Accountability Office, GAO, did a major study. They interviewed many of the people that have talked on our panels today, including Joe Gordon and others. And the Senate, by the time they had the actual hearings and invited people to come before the hearings, the Erickson community had managed to emerge from bankruptcy with a new owner and was able to go on without people losing their homes. And therefore the emergency had passed, you know. And so the Senate was not going to take any action on a national basis, and for important reasons. There were other financial industries that were in much worse shape, including the banking industry that was out there with hearings right across the hall at which they were enacting some major oversight legislation on a national basis for that. But in closing, what the GAO did say I think is important. They concluded that the report demonstrated that the importance of states being vigilant in their efforts to help ensure that CCRC residents' long-term interests are adequately protected cannot be overemphasized. So it still is a question for states to take a serious look at that. And I think that's what California is telling us they're going to do, that there's this is the start of a conversation, and the conversation is going to continue as this 10-year periodic review is going forward here in California. We hope this is helpful to that process. And I want to thank Shannon, I want to thank Matt, I want to thank everyone in the audience for being here, and everyone at McGeorge for all of the work that they have done in helping put this together. Let's give them a big round of applause. And our dedicated listeners online who sent in comments and concerns, thank you very much. We really appreciate your participation as well. We hope we've at least touched on most of your questions. Thank you, everyone. Be safe going home.